Court of Appeals is now in session.
Good afternoon, everyone, and welcome. We're pleased to welcome all of you for this afternoon's docket. We have two cases, and we will hear them in the order in which they appear. The parties, the appellant and the appellee, each have 15 minutes for argument, and the appellant, has the option of reserving up to 5 of that 15 minutes for rebuttal. So when you come to the podium after you've introduced yourself, please let us know how much time you wish to reserve, and we'll program the clock accordingly. Are there any announcements? There being none, please call the first case.
In re Estate of Gary Jake Hodges.
Good afternoon, Mr. Olson.
Good afternoon, sir. We would reserve 5 minutes.
5 minutes, very good.
And I will try not to use my full 10 minutes that remain. This is an appeal that addresses a matter undertaken by Judge Lockhart Mash out of the 23rd Judicial District. It has to do with an estate. And I won't go through it all, but the estate and matters associated with the estate have been through litigation. I think we were up here on another matter in this similar case, or adjoining case of
I think this is the third one.
Pardon me?
I think this is the third one that involves this.
It's actually a career. But,
Yeah.
but
I've got a question.
Yes, sir.
Normally, one does not open a probate estate or reopen a probate estate unless there is an asset or assets to be administered.
That's true.
What asset is there to be administered?
Don't know that there was an asset, but there was an asset right that was not assigned before the estate was reopened.
Well, it's my understanding that the attorney for the estate appeared before the judge in this case and presented an assignment from your client, the executrix, to your client, the individual.
That's correct. That's correct.
Okay.
But because of, and I think this is an abundance of caution, in my opinion, because of this has been litigated and litigated and litigated. As Your Honor notes, we've been up here a bunch. The next thing, I really thought, to be honest, that this would be something that would not be necessary to be heard. There's a statute in addition to the assignment. There's a statute that says, let's say that the estate goes away for whatever reason. It's just dismissed because it lays fallow when they decide to dismiss it. Well, there's a statute that provides that my client can then go collect. But honestly, and I'm sincere about this, each and every matter in this case has been litigated to the fullest.
Well, aside from all of that, it appears to be undisputed that the only remaining asset, if any, was assigned to your client as an individual, Miss Wall.
Correct.
So there's no estate asset.
Well, there's the right of the estate to the collection.
Well, no, not if it's been assigned to her.
That there is that argument, absolutely.
Well, I'm not making an argument. I'm reading the briefs, and even you said that if she can intervene, I'm going to quote, counsel would suggest that if Ms. Wall's motion is granted to intervene, which from the plain language of the statute seems appropriate, this appeal would be rendered moot, close quote.
It's not.
You said that.
I think Ms. Wall is the recipient.
Yes.
The party who intervened was Cordova.
No, I'm talking about Ms. Wall, at your motion, intervened in the circuit court litigation.
Ms. Wall was the executrix.
Yes, and at your hearing to reopen the estate, Mr. Runyon showed up and said, here's the assignment where this estate asset has been assigned to Ms. Wall individually.
That's correct. That's correct.
And you said in your brief, if Ms. Wall is allowed to intervene, in the lawsuit to recover an attorney's lien on the attorney's lien,
Okay, I understood.
then this appeal, why we're here today, is moot.
I agree with that 100%.
She was allowed to intervene.
I agree with that 100%. It's more than that,
So why are we here?
because the court hasn't acted.
They granted her a motion to intervene.
No. The court has not, we filed motions in, maybe we're talking about the wrong case.
No. In the brief by the Cordovas in this appeal, they said that your motion for your client, Ms. Wall, to intervene in the attorney Lynn case was granted.
I have not seen an order doing that. That's part of what I'm waiting on. And as a matter of fact, we found,
But you have filed the motion.
we filed the motion, and more than that,
And you've represented to that court that Ms. Wall owns that asset, the right
I
to
believe that she
recover.
does have that right,
Okay.
yes. I
So
absolutely.
you've represented to that court that she is the sole owner of that right.
I believe that she is.
Yeah, I'm not arguing with you.
Yeah, I believe that she is. But
So if she is the sole owner of that right, why do you want to open an estate that has no assets?
only to allow a formal assignment on the other side to be undertaken before this estate
The
is
attorney
closed.
for the estate has already presented the formal assignment in open court.
Agreed. This, I think you have to look, no, I think you have to look at the way that this litigation has gone on.
No, I'm not worried about the litigation. I'm focusing on one thing. You are seeking to reopen the decedent's estate
Correct.
on the representation that the decedent's estate owns the right to the attorney's lien against the Cordovas.
I think the representation was that we needed to go ahead and have the other court recognize what had been done. In other words, there's going to be an objection before Judge Wallace, who is the presiding judge who was hearing this matter, because procedurally, before the estate was closed.
But you're representing to Judge Wallace that Ms. Wall owns the asset.
Actually, what I've represented to Ms. Wall,
You've asked that she be allowed to intervene to prosecute the attorney's lien claim.
Absolutely.
Yeah.
Absolutely have done that.
Not the estate, but Ms. Wall.
That's correct.
Okay.
But that has to do more with the statute that I've quoted, 30
The statute is the enabling statute.
Right,
Who
30
owns the asset has nothing to do with the statute.
Well, when all the debts of a decedent's person are paid in full and the administrator or executor has resigned or is dead and there's no person representing the decedent, then it becomes the asset of the individual who would receive it.
Well, that would be the case, except it was already assigned to her by the executrix, which was her also.
Well, I agree.
Okay.
I agree. We're just trying to be absolutely positively correct in this because everything that has happened, and this will be advanced, whatever decision this court renders, will be advanced as a basis for Ms. Wall not being able to collect on the attorney's lien that her deceased father
Well, how
has.
can the estate collect if it no longer owns the asset?
Well, I think that the estate can assign and can allow, the estate can be opened for the purpose of allowing the change to be made in the court. Because that's going to be,
It's already been done. Mr. Runyon, are you disputing Mr. Runyon's representation in open court?
No.
He said the asset was assigned.
It was.
He presented it.
It was.
Then why are you here?
Because the objection is going to be proffered.
So,
Well, maybe I'm being overly.
the asset has been assigned. The attorney for the estate says the asset's been assigned.
I understand.
Your client, who's the executrix, says the asset's been assigned.
Correct.
Your client, who is the sole heir and the sole beneficiary of the estate, says it was assigned to her.
Okay. I think from the perspective of this, from my perspective, you have to look at it from the other side and say, why is it they're objecting to this? Why do they care? It's because it poses a potential objection to recovery in front of Judge Wallace. And I would be entirely comfortable if Judge Wallace had ruled
Well, then why did you say in your brief, counsel will suggest that if Ms. Wall's motion is granted, which from the plain language of statute seems appropriate, this appeal will be rendered moot?
I believe that to be correct. I believe that to be correct.
Okay.
The problem is that, and this is really the problem, I don't know that Judge Wallace has focused in on it because there's tremendous amounts of noise that come about with regards to this matter. Then what's going to be, we're going to be in front of the court, and the court, this is literally what's going to be said. Court, you can't do this because they didn't do this before the court, the probate court. And Judge Wallace is looking at that, and I'm just telling you what our experience has been.
Now, what is the mistake or inadvertent neglect that you're relying upon to reopen the estate?
It should have been, they should have, before the estate was closed, which terminated rights under the estate, there should have been a formal filing to change the parties in the trial court. That's my impression. And that's going to be the argument. That is their argument.
But you were the attorney in that case. Mr. Runyon was the attorney in the probate estate.
That's correct. But Mr. Runyon knew about the existence of this claim.
And he said he told you that he was closing the estate.
He did, but we discussed the fact that before we did that, we have to have this matter resolved. Now, in terms of, he said he wanted to try and close the estate. He didn't say, I'm going to do it here, I'm going to do it there. As a matter of fact, he came and testified and said, you know, that wasn't something that we did. That, you know, so I'm just, in my impression, if the court in Cheatham County would rule on our motion, this matter would be resolved, absolutely resolved.
Okay.
But the fact that they haven't ruled on what I consider, you know, I looked at the statute, the enabling legislation, you say, she's the sole heir. There is no case law on that.
Well, you don't even need to rely on the statute because this asset has been assigned to her.
I don't disagree. I don't disagree. But
All
I'm
right.
just telling, I just know that this is going to be a basis in some fashion. Smoke for Judge Wallace. Don't do anything. Don't do anything. And I'll tell you candidly, Judge Wallace has said the last time we were over there, he looked at us and said, why don't you guys resolve this? I've got murders I need to deal with. And I understand that. But what I don't want to have is anything that allows the trial judge to hang his hat on it and say, and Judge Wallace is a great judge and a friend of mine. We practice law across the street. Not close friends, but we have an acquaintance. We're good. I like Judge Wallace personally.
He's a very good judge.
Good lawyer. But the point is, his mind is, he's moved on from this. And respectfully, having done this a while,
Well, I'm confident that he will follow the law and follow the facts. But anyway.
I agree with you, but I think if he could in some fashion not address this, and I'm not saying he won't follow the law. I believe that he will. He's an excellent jurist. I think I just think that if I don't do everything absolutely correct and cross every T and dot every I, the problem is going to be that they're going to use that as a basis to not pay.
All right, thank you.
Thank you so much.
You've got 5 minutes for rebuttal.
Thank you.
All right. Good afternoon.
Good afternoon. May it please the court, my name is Dave Rich and I rise on behalf of the Cordova family. Today we are making 3 points, which is why this appeal is moot and should be summarily dismissed. First, there is no claim under Rule 60.02 for excusable neglect or mistake. Number 2, the Cordova family has standing under Rule 60.02 to challenge reopening the estate under Turner v. Turner, found at 473 Southwest 3rd, 257, and page 260. Finally, this court should dismiss any outstanding lien claims or other claims of the estate to those because it assigned its claims to Ms. Wall and is no longer an active entity. First, the standard of review. Yes, Your Honor.
Let me interrupt you. I may have misread your brief, but I thought you said that Ms. Wall has been granted leave to intervene in the other case?
She has, Your Honor, and more so, we actually filed a response with a supplement to this court and attached the order of the court. So the fact that Mr. Olson is unaware of this doesn't speak to the certificate of service that is on that order, as well as the double service that occurred through this court in our response or in our supplement to this
All
court.
right. If you don't mind, if you would file a motion for us to consider a post-judgment fact
Certainly,
and
Your Honor.
submit that order from the trial court along with it, and then my colleagues and I will entertain whether to grant that or not, and to what effect, if any, that will have upon the viability of this appeal.
Certainly, Your Honor, and just for the court's record, that order was entered by Judge Wallace on July 22nd of this year, July 22nd, 2022. The initial point that I'd like to make, and Your Honor, you stated most of what I was going to state today and through your questions, but I think it's also incumbent upon the court to understand the standard of review that applies to this case, which is an abuse of discretion. Rule 60 orders are based on the sound discretion of the trial court, and the scope of the review is to determine if that discretion of the lower court judge was abused. The trial court's decision to deny relief under Rule 60 is reviewed under that deferential standard, and we cited in our brief the Underwood versus Zurich Insurance Company case found at 854 Southwest 2nd, 94. The first point that we'd like to make is that no claim exists under Rule 60.02 for excusable neglect or mistake. The estate of Hodges waived any claim under Rule 60 to mistake, inadvertent surprise, or excusable neglect under Rule 60.02 by acknowledging under oath by Ms. Wall and through its attorneys that it sought deliberate closure of the estate after the lien claims had been pending for years. The estate of Hodges was also represented by not one but two separate law firms that advised it throughout that period to pursue closure of the estate. Number three, the estate's attorneys made a deliberate assignment of the lien claim, as Your Honor noted, to a non-lawyer, Rachel Wall, who was the executrix and assigned it to herself, showing that the act of closing the estate was premeditated and deliberate. Finally, the estate's motion for an enlargement of time in this case before this court and its appellate brief contain judicial admissions that preclude any claims under Rule 60. Certainly the text that Your Honor acknowledged where counsel identifies that this appeal would be moot. The second point, that the Cordova family has standing under 60.02, was challenged by the appellant in that reopening the estate, the Cordova family had no standing to challenge their attempt to reopen the estate. Well, the annotation to Rule 60 quotes the Turner case, stating, quote, if the party seeking relief after having had actual notice of the judgment manifested an intention to treat the judgment as valid. And I'll stop there. In this case, it's obvious that the estate of Hodges manifested an intent to rely upon the judgment. Not only did the lawyers advise the executrix, Ms. Wall, to petition the court to close the estate, Ms. Wall signed statements under oath verifying to the court that that's how she intended to move forward, and there was no appeal of that final order ever filed by the estate of Hodges to try to disturb that during the appropriate period of appeal. The second half of the annotation says that Rule 60 relief is not appropriate if granting the relief would impair, quote, another person's substantial interest of reliance on the judgment, end quote. And it's something of note to identify that the Turner court didn't say a party relied upon the judgment being closed. It says another person's substantial interest, identifying any third party out there that may rely upon the judgment and relying upon it being final. Clearly, in this case, the Cordova family relies upon the closure of the estate and actually informed Mr. Olson during the mediation, as we noted in our briefing materials, that that was the first time that he apparently learned that the estate had been closed. So under those two reasonings that are quoted in the annotation to Rule 60 of the Turner and Turner case, Rule 60 relief in this case is not appropriate. stating again, the estate explicitly manifested an intention to treat the judgment closing as valid, and did not seek to alter it until October of 2020. The estate was closed in October of 2020, but they didn't seek to reverse it until later after Mr. Olson sought to do so. And again, Mr. Olson jumped from the lien case where he represented the estate and then filed a notice of entry and appearance before the probate court. It wasn't Mr. Runyon's motion to reopen the estate. Finally, this court should dismiss any outstanding lien claims of the estate or to those it's assigned its claims, as it is no longer an active entity. A closed estate cannot pursue claims or exist as an open entity before the courts of this state after being closed by a court order. As Your Honor rightfully points out, the only time that estates are usually reopened in this state are when there's additional assets that need to be distributed. In this case, there is no asset. There is just simply a claim. And it's important for the court to know.
A claim can be an asset.
Certainly, Your Honor.
But if the claim has been assigned away from the estate to an individual, a beneficiary, then the estate no longer owns that claim/asset.
I completely agree, Your Honor, and that's where we find ourselves in this case. The assignment of the claim to Ms. Wall as the executrix to herself is a statement and an acknowledgement by the estate and Ms. Wall that the estate is no longer going to consider this an asset of itself, but is now an asset or a claim that Ms. Wall holds. Now, we've objected before Judge Wallace that Ms. Wall cannot pursue this lien claim, but that's another argument for another day as a non-lawyer attempting to share in an attorney's fee. And I think that what occurred here is that Mr. Runyon acted to close the estate. Mr. Olson wasn't aware of that. Mr. Olson then tried to reopen the estate because he understood that the estate could no longer appear in front of Judge Wallace and pursue this lien claim as a closed entity and sought to reopen it, and then learned at the hearing that was presented before Judge Lockhart Mash in Dixon County that there was this assignment. And that is what Judge Lockhart Mash based her denial of the Rule 60 relief upon, was that there was this assignment, that it was clear that Mr. Runyon had advised his client, along with Mr. Olson, to go ahead and close the estate, and that now they were having second thoughts about it because of what effect it would have on the ongoing lien claim. And the fact that Ms. Wall, as a non-attorney, as an individual, and she doesn't stand as anything more than an individual now before Judge Wallace's court, that she's been substituted. And the estate of Hodges is no longer a party to the litigation. So the litigation and the lien claim now exists as the Cordova family versus Ms. Wall. So that act of substitution, which has already occurred, and if Mr. Olson is unaware of that, again, it's kind of par for the course. This order was filed back at the end of July. All parties were attached to it. That order has not been disturbed, and the order states specifically that Ms. Wall has been substituted for the estate of Hodges, and the estate of Hodges has now been dismissed. So rather than the estate of Hodges dismissing this appeal, which it identifies in both its motion to extend time and in its brief that it should have done, it nevertheless continues forward and sojourns before this court to try to get an order to overturn Judge Lockhart Mash's order under Rule 60, providing Rule 60 relief that the estate should be reopened. It's clear that this appeal should not have been filed, or if at any point it should have been abandoned at some point. But nevertheless, we're here and we're arguing about it. And simply stated, the court should recognize that the proactive efforts and the deliberate efforts of the estate of Hodges through its executrix, Ms. Wall, was represented and given legal advice by not one but two separate attorneys, and went forward under those conditions to ask that the estate be closed. And Judge Lockhart Mash agreed and provided an order that said, okay, we will close the estate. And didn't do so just on the representations of the attorneys alone. Did so under the sworn oath of Ms. Wall, stating that she wished for the estate to be closed. The final thing that I want to respond to are just a few different points that were made in the briefing materials that were provided by the appellant. And that is that Attorney Olson states in the brief, quote, "The most simply of mistakes were made. Counsel just did not inform counsel in a companion case that the case would be dismissed." And that's found on page 15 of the appellant's brief. That is simply false. As Judge Lockhart Mash identified, based on the sworn testimony of Mr. Runyon, that there was no mistake here, that Mr. Runyon did testify that he informed Mr. Olson that they were going to move forward and close the estate, and he was aware of these things in advance. Finally, the brief also states on page 15, quote, "It was a mistake that really affected no other party." The Cordova family and its attorneys settled this matter and resolved this matter. The core case that exists here is that the original attorneys, Mr. Hodges, who is now passed, as well as Mr. Martin, entertained this case and simply tried to get this case settled without performing any investigation or any effort to try to resolve this case on the merits. It was a year later that Ms. Cordova, on behalf of her family, finally fired her attorneys and said, "Nothing's been done, and I wish to get another law firm." The settlement offers that were entertained by the original attorneys were a fraction, a small fraction of what this case actually was valued at and got resolved for. And that was back in September of 2016.
We're sort of running far afield here from the Rule 60 request and opening a state, aren't we? We're getting into the merits of the other suit.
Certainly, Your Honor. And the only reason I bring that up is that this protraction of the litigation, of what we're ultimately trying to solve here, is very simple. What lien, if any, is Mr. Hodges, when he was alive, and now the estate of Hodges, and now Ms. Wall on behalf of the Hodges, if any, are they entitled to?
Well, and I mean, it sounds like though the estate's argument here is that this was filed as a purely a cautionary measure to make sure that the individual could be substituted, and it looks like that individual has been substituted. So that seems to moot this out.
I would certainly agree with Your Honor, but this appeal didn't need to go forward. We certainly have the ability as lawyers to recognize facts and then make moves upon them. And in this case, when the estate recognized that their claim was moot, that they could have dismissed the appeal and they chose not to do so. But with Your Honor's permission, I will file that supplemental brief to ask the court to consider those additional facts.
Actually, a motion for post-judgment facts. I don't remember the rule of appellate procedure number, but it should be under the rules of appellate procedure, motions to consider post-judgment facts. And if you have that order granting the intervention, plus if you have the assignment from the estate to Ms. Wall, that may have bearing on what we do or don't do.
Understood, Your Honor, and I would just offer that I think both are a part of the record that I confirmed from Cheatham County that went up. So I will file that motion and reference those items in the record.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Rich. Mr. Olson?
Just briefly, if I was sitting here through the miracle of telephone, texting my assistant saying, "Do we see that? Do we see that?" And she called, and there's some order. I haven't seen it yet, but if it's an order that grants my motion from March of this year, then in my mind, that moots this.
Apparently, it was entered on July the 22nd of this year.
And if that's the case, then I'm satisfied, although I
Okay.
think that I'm fully convinced, based on counsel's argument, that we will have continuing arguments. Oh, no,
Sure.
because, you know, but the court has ruled on that. If Judge Wallace signed that, that's fine. But I can tell Your Honor, and I think counsel and I both have called occasionally Miss Valerie Hawkins and said, "Hey, is this," and I was unaware that there was an order.
Well, it was in the appellee's brief.
Well, I didn't see it. I apologize.
Yeah,
I've been.
All right, well, we'll just, if it is, it is, and of course you've
You know,
got.
if it's there, I will file a stipulation dismissing this.
Very good. All right.
Because if he's granted that, which he very well may have, which I think he should have, and as I said in my brief, if he did that, I think he moots it.
Good. All right.
I think it's moot.
Okay. Well,
That-
Thank you, Mr. Olson and Mr. Rich, for your arguments.
And I'll be honest with you, I'm gonna drive back through Cheatham County and I'm gonna see if it's there, and if it is,
Very
I'll
good.
file a stipulation.
Highway 12 is a lovely drive, so,
It's been a little dry this year.
yeah, okay.
Thank you very much.
All right, thank you both. Okay. Call the next case, please.
In Ray Emberly W. et al.